The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to today's Law of Self-Defense content. I am, of course, attorney Andrew Branca for Law of Self-Defense. Today I'd like to share with you some updated legal analysis of the Alec Baldwin on-set shooting of Helena Hutchins, a 42-year-old mother and the director of cinematography for Baldwin's in-production Western movie Rust. Ms. Hutchins tragically died as a result of that shot. Also injured by the shot was director Joel Souza, who appears to have survived his injuries. Now, spoiler, the more we learn about the facts of this case within the context of New Mexico criminal law, the more this shooting looks increasingly like a crime, specifically felony involuntary manslaughter. So today, let's explore that possibility in further detail. Before I do that, however, I'd like to give a shout out to our sponsor for today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay its members legal expenses if the member's involved in a use of force event, and those expenses start big and get bigger fast. Folks, if you've killed someone in self-defense, find yourself charged with murder or manslaughter, it's easy to burn through $200,000 before you even get to the trial, much less the cost of the trial itself. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought, as if the rest of your life depends on it, because it really does. Now, I've looked at all the companies that offer similar services, and I found that CCW Safe is by far the best fit for me. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can save 10% off your membership using the discount code LOSD10, LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCW Safe. All right, folks. So last Friday, we shared some analysis with all of you immediately after this tragic event, which occurred just the day prior, and during which there remained considerable uncertainty and speculation regarding relevant facts surrounding what happened in the shooting of Miss Hutchins. And given the fog of war circumstances on Friday, rather than advance towards a right answer as to the likely legal consequences of the shooting, we instead framed our analysis last Friday in terms of at least asking the right questions. So accordingly, we explored last Friday whether this tragic shooting might best be characterized as an accident in the technical legal sense, where there's no legal liability, or mere negligence, giving rise to only civil liability, or perhaps recklessness, giving rise to criminal liability, specifically involuntary manslaughter. Since last Friday, however, it appears that certain facts have been established that have moved us rather hard towards the right side of that continuum and towards a conclusion that this tragic event looks increasingly like felony involuntary manslaughter. Now, some of the relevant facts we're presuming to be established for purposes of this analysis include, first, that it was Alec Baldwin who manipulated the gun that fired the projectile that killed Ms. Hutchins. Second, that the gun discharged because the trigger was depressed by Baldwin and not because of some defect in the weapon. Third, that the muzzle of the weapon was directed towards Ms. Hutchins by Baldwin when it was fired. In other words, she wasn't killed by some unpredictable ricochet. Fourth, that the gun contained a live round, the bullet of which struck and killed Ms. Hutchins. And fifth, that Baldwin had the opportunity to inspect the weapon for live ammo before he directed it at Ms. Hutchins and pressed the trigger, killing her. And of course, that there was no justification for the shooting of Ms. Hutchins. This was not some act of lawful self-defense, which clearly it was not. Separately, we are assuming for purposes of today's analysis that Baldwin did not intend to injure Ms. Hutchins. If such intent to harm were established, we'd obviously be looking at a much more serious criminal charge than mere involuntary manslaughter. So, assuming, as we are, these facts to be established, it would certainly appear that they are more than sufficient to justify a criminal charge of involuntary manslaughter under New Mexico law and to support a conviction beyond a reasonable doubt on that charge. So let's start first by taking a look at the relevant New Mexico involuntary manslaughter statute, which is Statute 30-2-3. It's titled Manslaughter. We do, of course, link to the statute in the text version of today's content. Now, that relevant New Mexico statute on involuntary manslaughter, as I said, is Section 32.3, titled Manslaughter, but it addresses both voluntary and involuntary manslaughter. Our focus here, of course, is on involuntary manslaughter. In the context of involuntary manslaughter, Statute 30-2-3 reads in relevant part, quote, manslaughter is the unlawful killing of a human being without malice. Malice would make it murder. Involuntary manslaughter consists of manslaughter, meaning that unlawful killing of a human, committed in the commission of a lawful act which might produce death, so an inherently dangerous act, without due caution and circumspection. Well, when we consider the elements of that statutory language, Ms. Hutchins is obviously killed. We have stipulated that the killing of Ms. Hutchins was not justified. It wasn't self-defense or something, so it was clearly unlawful. It was, we're presuming, without malice, so without intent to cause harm. So that meets the conditions of the first sentence of the manslaughter statute, defining manslaughter itself, and it satisfies the definition of manslaughter under New Mexico law. The possibility of voluntary manslaughter appears to be off the table here, given the lack of evidence of a sudden quarrel or heat of passion, which are required for the crime of voluntary manslaughter. So that leaves us to consider the possibility of involuntary manslaughter. The key then is to determine whether Baldwin's pointing of the gun at Ms. Hutchins and pressing the trigger without first ensuring that the gun did not contain live ammo, was that conduct the commission of a lawful act which might produce death, and that was done without due caution and circumspection. So let's talk about inherently dangerous instruments, because that's what a gun is, an inherently dangerous instrument. So in order to understand what due caution and circumspection means in the context of an inherently dangerous instrument such as a firearm, we have to look at what makes firearms inherently dangerous and how does society set expectations for the use and handling of firearms, where that use would qualify as having used due caution and circumspection. So it's, of course, common knowledge that firearms are dangerous instruments, inherently dangerous instruments. So the law presumes that, because it's common knowledge, that we all possess such knowledge. In the case of Baldwin, in particular, he actually sits on the board of a gun control organization whose existence is premised on the fact that guns are dangerous. So he can certainly be presumed to possess this knowledge that guns are inherently dangerous instruments. Items are inherently dangerous when they can readily cause death or serious bodily injury to people if used carelessly. And guns clearly qualify, as we've already noted. Also in this category of inherently dangerous instruments would be things like explosives and heavy equipment, dangerous drugs or chemicals. Use of these items takes particular and specialized care if death or serious bodily injury is to be avoided. Now, it happens also that inherently dangerous instruments are often exceptionally useful. Guns, for example, are exceptionally useful compared to the available alternatives for purposes of defense and hunting. Explosives are exceptionally useful for mining and road construction and demolition. Dangerous drugs are exceptionally useful for human health and dangerous chemicals for various industries. So society wants to realize the value of these various inherently dangerous instruments, but also wants to balance that value against the considerable risk of harm these inherently dangerous instruments might cause. And that balance is achieved by imposing the following rule. Anyone making use of an inherently dangerous instrument is strictly liable for any unnecessary harm that they cause, no excuses, period. The burden is placed on the person using the inherently dangerous instrument to ensure that they take whatever steps are required in order to not cause unnecessary harm. And if they do cause unnecessary harm, they bear absolute responsibility for that harm. No excuses. What this all boils down to is that for any category of inherently dangerous instrument, there will have been rules developed for the safe use of that instrument. Follow the rules, and the value of the instrument can be realized without much risk of serious harm. Fail to follow the rules, and serious harm becomes quite likely, and again, the user then bears absolute responsibility for having caused that harm. No excuses. Now, if safe use of an inherently dangerous instrument would not be possible, even if safety rules were followed, that instrument would simply be prohibited from general use as too dangerous to be worth the risk. The juice wouldn't be worth the squeeze. What this means in the context of firearms, a particular class of inherently dangerous instruments with a considerable potential for causing unnecessary death and serious harm to others if used unsafely, is that there exists a series of safety rules for their responsible operation. These rules are well established and widely recognized, and even better, there's only 4 of them. So, phrased in the context most relevant to the facts of this case, the 4 rules for safe gun handling are: first, all guns are presumed to be loaded until the gun handler personally verifies otherwise, and that verification becomes invalid the moment the gun leaves the handler's control. Second, never point the muzzle of a firearm at anything you are not willing to kill or destroy. Third, never press the trigger of a firearm unless you intend for it to fire a bullet from the barrel. And fourth, know your target, know what you're shooting at, and what is beyond your target. Now, that last safety rule is intended to recognize things like the dangers presented by bullets that can penetrate objects and proceed onward to strike unintended people and things, as well as to help prevent hunters from shooting each other because of mistaken identification as game. So that one isn't particularly relevant to our analysis here. But the first 3 safety rules, however, are intensely relevant to the facts of this case. As the safety rules for safe gun handling, they define what is meant by the statutory element of due caution and circumspection in the context of handling firearms. And one interesting, really beautiful facet of the gun safety rules is that they are redundant in the technical sense of meaning that violating any single one of them will not necessarily have a bad outcome. Indeed, a bad outcome in the sense of death or serious bodily injury can really only happen not if one of those 3 safety rules are violated or even 2 of them, but instead requires that the gun handler manage to violate all 3 of those gun handling safety rules. So to illustrate, merely mistakenly believing a gun does not contain live ammo, in other words, it's actually loaded, but you don't know that, but neither point it at anyone nor press the trigger and no harm results. Merely point the muzzle at someone, but first ensure the gun does not contain live ammo and don't depress the trigger and no harm results. Merely press the trigger, but first ensure the gun does not contain live ammo and don't point the muzzle at anyone, and no harm results. Now, I'm not suggesting anyone does any of those things. They're all, as far as I'm concerned, as a firearms instructor myself, violating any one of the safe gun handling safety rules is a formula for disaster because it's too easy to stack the errors. But the truth is, dangerous harm, death, and serious bodily injury can really only result when all 3 of those rules are violated. Break all 3 of those safety rules. Mistakenly believe your gun, which actually contains live ammo, mistakenly believe it's unloaded, point the muzzle at another person, and press the trigger, and you have a very bad outcome indeed. And that's precisely why the safety rules exist. So when handling an inherently dangerous instrument in the form of a gun, bad outcomes, death and serious bodily injury can be avoided. So how does one handle a firearm with due caution and circumspection, as required by the Involuntary Manslaughter Statute if you're not to be guilty of that crime? Well, you do it by adhering to those safety rules when handling the firearm. When is a person handling a firearm failing to do so? with due caution and circumspection, triggering that element, satisfying that element of the involuntary manslaughter statute, when they're handling that firearm in a manner that violates one or more of those safety rules, and especially when they're violating all the safety rules. Now, based on the apparent facts of this case, it appears incontestable that Alec Baldwin violated all three of those primary gun handling safety rules when he engaged in the conduct that killed Miss Hutchins. First, he pointed the muzzle in her direction, presumably directly at her. Second, he pressed the trigger in the manner designed to fire the weapon. Third, he failed to first ensure that the weapon did not contain a live round. And the tragic, sadly predictable result, the unintended discharge of the bullet into Miss Hutchins, killing her. That, in a nutshell, certainly appears to be the commission of a lawful act which might produce death without due caution and circumspection, which is the language of the involuntary manslaughter statute. Now, another angle from which we can inspect this question of whether Baldwin's conduct qualifies as involuntary manslaughter under New Mexico law is to take a look at the relevant New Mexico jury instruction, which is 14-231, involuntary manslaughter. Again, that's linked in the text version of today's content. And as always, I do encourage you to take a look at the actual law. You don't have to take my word for it. So while jury instructions are not, technically speaking, authoritative sources of law themselves, the authoritative sources of law are statutes and court decisions or case law, jury instructions are a useful amalgamation of the statutory language and how the courts want that language applied to real people in real cases. And because they are instructions intended for a jury of lay people, not legal experts, they also tend to be written in plain English far more often than statutes or court decisions are written. Indeed, they're often written in a fill-in-the-blanks kind of format to make them easy to use consistently from trial to trial, and that's precisely how New Mexico structures its uniform jury instructions. So here's how jury instruction 14-231 on involuntary manslaughter would be read to the jury if the blanks were filled in with relevant facts from Baldwin's shooting of Miss Hutchins. Quote, "For you to find the defendant guilty of involuntary manslaughter, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. First, that Alec Baldwin pointed a loaded firearm at Miss Hutchins and depressed the trigger, firing a bullet into her. Second, that Alec Baldwin should have known of the danger involved by Alec Baldwin's actions. Third, that Alec Baldwin acted with a willful disregard for the safety of others. Fourth, Alec Baldwin's act caused the death of Miss Hutchins. And fifth, that this happened in New Mexico on or about the 21st day of October, 2021. The close quote. The know of the danger and willful disregard portions of the jury instruction correspond to the due caution and circumspection language of Statute 30-2-3, and the matter of willful in the jury instruction merely refers to the fact that whether to first inspect the gun to ensure that it did not contain live ammo was within Baldwin's control. There was no outside force compelling him to not safety check the firearm before he pointed it at Miss Hutchins and fired it. So again, this time based on the New Mexico jury instruction on involuntary manslaughter, it seems incontestable, based on the evidence as it appears to be, that Baldwin's conduct meets the legal conditions for the crime of felony involuntary manslaughter. Now, I know what a lot of you are thinking. You're thinking, hey, Andrew, but is there any case law on this? One of the most common questions I get. And of course, we're not done yet. So having looked at the relevant New Mexico statute and jury instruction on involuntary manslaughter, we ought also consider whether there's any New Mexico case law, appellate court decisions that would seem to apply to this question of whether handling a loaded gun in an unsafe manner, such an unsafe manner that you unintentionally kill someone, meets the legal standard for the crime of felony involuntary manslaughter. And as it happens, there is indeed New Mexico case law precisely on this point. And that case law is a decision out of the New Mexico Supreme Court itself. It's State v. Gilliam. We do link it in the text version of today's content, but for those who'd like to look it up yourselves, the citation is 288 Pacific 2nd, 675. It's a decision out of the New Mexico Supreme Court from 1955. Now, for any of you who may be concerned that Gilliam, a decision handed down in 1955, is out of date, be not afraid. Case law is perfectly valid law until there's some constitutional or statutory or later court decision that modifies or reverses the applied legal standard. Valid case law does not simply expire, and I used my office's professional legal database resource, Lexis, to ensure that Gilliam remains good law in New Mexico. Now, the decision was an appeal of a criminal conviction at a jury trial in which the defendant had been found guilty of involuntary manslaughter by the act of unsafely handling a gun, with the result that it discharged and killed the victim. The New Mexico Supreme Court ruled in that decision in relevant part that, quote, it could have made no difference to the trial of a charge of involuntary manslaughter as to who loaded the gun. All that is necessary to establish for involuntary manslaughter by the use of a loaded firearm is that a defendant had in his hands a gun, which at some time had been loaded, and that he handled it without due caution and circumspection, and that death resulted. Close quote. So it doesn't matter who loaded the gun, meaning all this talk about whether the live round in the gun came from this source or that source or some other source is largely irrelevant for purposes of determining whether Baldwin's shooting of Ms. Hutchins was involuntary manslaughter under New Mexico law. All that matters in the context of involuntary manslaughter through unsafe handling of a firearm is that, and again I quote, the defendant had in his hands a gun which at some time had been loaded, and that he handled it without due caution and circumspection, and that death resulted. Now, clearly, Baldwin had in his hands a gun which at some time had been loaded. And as we've already demonstrated, by so thoroughly violating the well-established and mandatory rules of gun safety, he also handled it without due caution and circumspection. And finally, we know for certain the tragic outcome of this conduct, that Ms. Hitchens' death resulted. So again, it's hard to see how Baldwin's fatal shooting of Ms. Hitchens, based on the facts as we believe them to have been established, could fail to qualify as involuntary manslaughter under New Mexico law. Now, I also want to mention I see a lot of hand-wringing attempting to assign blame for this tragedy to, it seems, everybody other than Baldwin. Frankly, the intensity of these efforts suggests to me that they're part of an orchestrated crisis management initiative put into play on Baldwin's behalf. And that's a smart move by Baldwin, if in fact that's what he's done. It's why such crisis management firms exist. And it is indeed possible that other people also bear some responsibility, perhaps even criminal responsibility, for this tragedy. Perhaps safety rules were broken and professional duties were failed, or adequate resources to ensure safety were not provided. None of that, however, at all diminishes the responsibility under law for Baldwin to handle that inherently dangerous instrument, the gun, with due caution and circumspection. And that he failed to do when he pointed the gun at Miss Hitchens and pressed the trigger without first personally ensuring that the weapon did not contain a live round. Whatever mistakes others might have made previously, had Baldwin broken even one less of the fundamental gun safety rules, had he not pointed the gun at Miss Hitchens, or had he not pressed the trigger, or had he assumed the gun contained live ammo until he personally determined otherwise, Miss Hitchens would not have died from that bullet on that day. Her fate ultimately rested entirely in the hands of Alec Baldwin. And it appears he failed her, and he failed the law of New Mexico. Another bit of hand-wringing I'm seeing a lot of is the notion that the rules should be different for Baldwin because he's an actor. And actors often point guns at each other in various roles. It's what they do. They're different. Well, first of all, the reality that actors do often point guns at each other in various roles, and that they do it almost invariably without unintentionally shooting someone, is a credit generally to Hollywood safety practices and only highlights, to an even greater extent, why adhering to due caution and circumspection is so vital when handling firearms. When the safety rules are followed, no harm results. When Baldwin willfully violates the safety rules, Miss Hitchens dies. The death of Miss Hitchens is not a Hollywood problem. Hollywood has a pretty darn good safety record in gun handling. It's an Alec Baldwin problem. From a more legal perspective, however, there's nothing about being an actor that entitles someone to create an unjustified risk of killing someone, disregarding that risk, and then killing that person. There's no involuntary manslaughter freebie for actors. If they kill someone recklessly, they are as guilty of involuntary manslaughter as is the fellow down the street who drunkenly runs over the nun in the crosswalk. There's no special actor court. Now, having said that there's no special actor court, any charging decision is ultimately at the sole discretion of the local prosecutor. And while such charging decisions should always be, but sometimes aren't, based on adequate legal merit to believe guilt can be proven beyond a reasonable doubt, in high-profile cases such as this one, charging decisions often become political in nature as well. So should the local prosecutor choose to not charge Baldwin, then he'll likely never face a trial on the felony charge of involuntary manslaughter. And that would be a lucky break indeed for Alec Baldwin. If, on the other hand, the prosecutor decides to charge Baldwin with involuntary manslaughter on the evidence as we believe it to have been established, it looks like a walk-away conviction to me, at least on the actual legal merits. I always have to caution juries are, as always, dangerous and unpredictable creatures, so there's never any guarantee of anything in criminal trial. But on the legal merits, this looks like involuntary manslaughter to me every day of the week, twice on Sunday, based on the evidence as we believe it to have been established. Okay, folks, that's all I have for you on this particular topic today. I imagine we'll be writing more about it as we move forward. Remember, if you carry a gun, so you're hard to kill, which is why I carry a gun, so I'm hard to kill, my family is hard to kill. First, please, of course, carry it safely. Know those 4 rules of gun safety and adhere to them religiously. But if you carry a gun so that you're hard to kill, you also owe it to yourself and your family to make sure that you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.